What are the matters that my spouse and I must address to conclude our divorce? Do they have to be decided in any particular order? Are there any subjects that can be omitted? These are the questions and others that we're going to answer today. I'm Michael Miller, a partner at Cole Miller PLLC, located in Vienna, Virginia. We're a family law firm serving primarily in the Northern Virginia area. I analyze challenges and I find affordable solutions for families and their legal needs. Now, we just recently finished a 3-part series that addressed the COVID pandemic, the impact that it's had on the courts, and the consequences that has with trying to enforce custody and parenting time, as well as the challenges that can arise in the modification of family support. We're going to turn our attention today to the 5 areas that have to be addressed in order to conclude a divorce. So they are, as a quick overview, you first have to address matters of property, then you have to look at matters of the debts and the obligations of the family. Next, you use spousal support. Then you look at custody visitation. And then the 5th and final issue is matters of child support. So with regard to matters of property, this is controlled by Virginia Statute 20-107.3. Now, the statutes are kind of out of order because we have to do property first. It's at 107.3. And then next we're going to do spousal support, which is 107.1. But the statute 107.3 says, upon decreeing a divorce, the court proceeds with dividing property. So it has to be done first. What we're doing here as the property division is we are looking at identifying the property. So the parties, the spouses, have to take all the property there is of any kind: automobiles, bank accounts, real estate, airplanes, stocks, bonds, everything goes on the table. So then the property is then identified as to what there is. Then we go through each piece of property and we classify it. It's either going to be classified as marital property, it's going to be classified as separate property, or it could be classified as a mix of the two. For example, if you have a 401k or an IRA retirement plan from before the marriage, that would be separate because it falls within the definition of separate properties, property owned or acquired prior to the marriage. However, during the marriage, you may make contributions to that plan, and so property acquired and the contributions to the plan during the marriage would be classified as marital property, and then upon the date of separation, anything that occurs after that is separate property. So with the one account, you could have premarital separate contributions, marital contributions, and then post-separation separate contributions. Then once the property is classified, everything that's separate comes off the table and goes to whoever's separate property that is. With what's left, which is the marital property and the hybrid property, we then have to go through and value that. Property assets are valued as of the date of the hearing. There is a provision that you can file a motion 21 days in advance of trial to ask the court for a different trial date. Then, once the property is valued, then the court conducts the equitable distribution process, where you go through the 11 factors at paragraph E in Virginia Code 20-107.3. Now, typically, property is not modifiable. So it's a one and done sort of deal. You go to court, put the property out there, go through and divide it up, and then either by agreement or from the ruling of the judge, then that divides the property, and that's the way it is for all time. This will be different as compared to both spousal support and child support that could be modifiable, as well as custody visitation. A couple other things here is, with regard to matters of property division, entire books are written on this. Even the subparts have entire books written on them. So we're just going to do a quick skim over top of this and kind of get a lay of the land here. What I foresee is that this particular presentation kind of becomes the nucleus, then that people can come through. They may be able to watch a video on personal efforts, see how that impacts on separate property, watch a video on the classification of property. That may lead them then to this 5-part video that we addressed today. And then from there, they can spin back out and go look at matters of custody, visitation, spousal support, child support, stuff like that. So other matter here with regard to property that we're not going to have time to look at today, and we will talk about more detail in another video, is the list of presumptions and burdens that are described in the statute. So you may have separate property. If it's retitled during the marriage, the presumption is then that separate property is converted to marital property because it's been retitled. There are burdens as to who has the burden of proof to come forward to try to present the evidence to rebut the presumptions and things like that. Now, with regard to debts, everybody wants to forget about the debts. Normally, when you do the property division, whoever gets the house gets the mortgage, whoever gets the car loan. So those kind of address themselves because they're usually significant debts, and they go with property that people have an interest in. The debts that people forget about, though, are the credit cards and the unsecured debts and things like that. There's Visa balances, MasterCard balances, Discover card balances. We went out, we bought some tires, we bought some groceries, we went to the movie. Not really sure where the balance came from, but lo and behold, there's $5,000 or $7,000 on that credit card. So, but there's not really any asset associated with it. So when you're doing your either settlement negotiations, your mediation, or you're doing your litigation, you want to make sure that you account for these debts and make sure somebody's going to be responsible for them. In the absence of an agreement between the parties as to who's going to be responsible, then whoever's name is on that account will be responsible. Ultimately, the parties cannot contract away the lender's security. So if both parties applied for the car loan, the lender will have recourse against both of them so long as they both remain on the note. Also, the difference here we talked about earlier is property is valued as of the date of the hearing, and with regard to debts, they are valued as of the date of separation. So far we've looked at property, we've looked at debts. Our third of the 5 issues now is spousal support. Spousal support is synonymous with alimony or maintenance or separate maintenance. So the idea here is one spouse is providing financial support to the other spouse. Spousal support can come from 2 different statutory authorities. The first one is Virginia Code 20-103. That's for the pendente lite or the temporary support, the pendente lite, pending litigation. Usually what that addresses is the period between when the parties separate and then a year or so later when they divorce. We have to cover that year period there. So to make it possible to determine this in a timely fashion, the courts have come up with a formula, and we'll apply that so that temporary support for both the spouse and the children can be established on a regular motions day. And then once we get to the end of the trial and now all the information comes out and we have more time to present evidence and consider the case, then the judge would use the second statutory authority, which is Virginia Code 20-107.1, to go through and look at the circumstances of the parties and then come up with what would be called a permanent spousal support. That amount can then be made retroactive to apply back during the pendente lite period. So it will balance out eventually. So the idea is we come up with a temporary number. It may not be fair to either party, but at least it's a ballpark number that comes pretty close, and then we can refine that and come up with a better number towards the end of the case. With regard to the spousal support through 20-107.1, there can be terminating events there. The terminating events can be the death of either party, the remarriage of the recipient, or the cohabitation of the recipient in a relationship analogous to marriage for 1 year or more. Also, what we look at here in the spousal support determination is imputed income. So for a party who wishes to receive spousal support, they have the first obligation to try to support themselves by becoming fully employed. And that in itself becomes a whole another body of inquiry, because if someone claims they're not employed, or that if the other side asserts that they're underemployed, then there are vocational experts that you can retain. They will come in and do a vocational assessment on that spouse and find out what could they be reasonably expected to earn today with their skill set. The vocational assessment could also include any kind of recommendations. For instance, if a person may have a degree in accounting but has their CPA license lapsed, then the vocational assessment would come back and recommend that this person pick up the necessary coursework to get caught up in their profession, and then take the exam possibly to get their CPA license or something like that. And we'll talk about these issues in more detail in the coming segment that's on spousal support. Thing here, spousal support, if ordered by the court, can be modified. What's interesting is in some cases the judge will set a high amount of support without any kind of change date coming, with the expectation that the recipient spouse will become employed, and then leave it to the payor spouse then to seek a modification. Other judges will take the vocational assessor's report and say, well, if this person will be fully employed in 12 months' time, so what the judge can do, or it has done, is they will put the amount of support, say, at $2,000, and that would be for the next 12 months, with the expectation then that the spouse will be fully employed at the end of 12 months, and so there would be an automatic step down. So in this instance, they're not requiring or implying that the parties need to come back for modification. The modification kind of triggers itself after a period of time. Then the fourth area we look at is the custody and visitation of minor children. Custody visitation comes in a couple of different flavors. There's legal custody, which is the power to make decisions regarding the children's welfare. There's physical custody, which looks at with which parent does the child live more than the other parent. And then the flip side of that is the what's called either visitation, or the more current term now is parenting time. So the idea is on the physical custody or the parenting time is, the whole spectrum is wide open on this. Some parents can come in and say, look, child's going to live with parent A. We'll work out the details for the children to see parent B, and they can work that out. And you don't need to go through with a bunch of definitions as to what holidays are, who has what times, or anything like that. Other families need more structure than that. They need to have it defined that, the children may live with parent A. Parent B has Wednesday nights for dinner, alternating weekends from Friday evening to Monday morning, 2 weeks in the summer, split the holidays and things like that. Of course, the time can be anything from all to one as arranged to the other parent, or you can go clear to the other extreme and do week on, week off, or 2-2-5-5 schedule, the 2-2-5-5 being 2 days with parent A, 2 days with parent B, then the next 3 days go to parent A. They take their 3 days and join to their 2 days they would otherwise have, so that becomes the 5. Then the other parent gets their 2 days with the 5 following, so 2-2-5-5. And it just depends on the age of the children and what their schedules are. Younger kids, preschool age, can move back and forth a little more easily than children who are in school. It also depends on how far away the parents live from each other. If you do week on, week off, if both parents get the child up at the same time, take them to the same daycare or the daily activity, then you keep some stability and structure with the child. Smaller children may not do well being apart from the other parent for a year, or for a week rather. So what you would do is you would do maybe like the 2-2-5-5, whereas the older children that can become more accustomed to being away from the other parent for a week, you could do week on, week off, or something like that. It doesn't have to necessarily be on a weekly basis. You could also look at one parent during the school year, another parent during the summer. So wide variety of ways to solve the issues here. At the end of the day, though, if the court has to decide matters of custody visitation, they're going to look at the factors at Virginia Code 20-124.3. We'll talk about those in more detail here and shortly in the upcoming presentation. And then the final of the fifth areas that we look at is child support. And with regard to child support, there's always the guideline determination first that you find at Virginia Code 20-108.2. That's presumed correct. However, the parties can present evidence to rebut that presumption. And then if the judge finds that the guideline amount is unjust or inappropriate, then the judge can make written findings of that. And then you go back to Virginia Code 20-108.1, and there are a list of deviation factors there as to how the court then can vary from the guideline amount of support. Incomes, or in order to determine the guideline amount of child support, you need the income of each parent, you need the cost of work-related daycare, you need the cost of health insurance, and you need to know the visitation custody schedule. Also, with regard to child support, there are terminating events on that. Child support is payable until the child attains age 18. However, if the child is still in high school at age 18, then the child support would continue until either the child graduates high school or the child's 19th birthday. There are also some provisions in the statute for children who have a disability that would preclude them from supporting themselves. So long as they continue to live with that parent, then child support can be continued past the 18th or 19th birthday, as the case may be. Now, the reason we do these five things in the order that we do can most easily be understood by looking at them in reverse. So we do child support last because child support is dependent upon each parent's income. Well, spousal support takes each parent's income, each spouse's income, but it adjusts it because when the payor spouse pays the other spouse, that reduces the first spouse's income and increases the second spouse's income. So you have to know what the spousal support is and the adjustments to income as part of your guideline calculation. Likewise, as I said, the days of custody or the days of parenting time also factor into the child support formula. So what you want to do is look and see whether both parents have more than 90 days of time with the children. To count as anything, you have to have at least an overnight. So if you pick the child up at 1 o'clock in the morning and drop them off at 11 o'clock at night, that counts as 0. If you pick them up at 11 o'clock at night, drop them off at 9 o'clock the next morning, that counts as a half because that's at least an overnight. And then as you closer you get to the 24-hour mark, then that would count as 1. If both parents have more than 90 days in the course of a year, then the child support formula is modified. It starts off with each parent's income, add that together by the guidelines, that produces an amount of support for the children that's then shared between the parents in proportion to their incomes. But then when we add the shared custody element to that, each parent's portion is then further divided and shared in proportion to time. So you have the double sharing, both in proportion to income and in proportion to time. As I said, so for child support, you need to have the custody schedule. That's why we have to do that before we can do the support calculation. And we also have to have the spousal support determination. We'll talk about this in more detail in a following presentation, but spousal support in part is determined upon the financial resources of each party, the equitable distribution results from dividing the property and the debts, and things like that. So that's why we have to divide property and debts first, so we know that information to put into the spousal support determination. And then, as I said there at the beginning, the statute says the court conducts equitable distribution upon decreeing a divorce. So that's our 5 areas that we look at, and this would apply across the board. If you're going to mediation to settle your case, you look at these 5 areas. If you go to litigation, if you do 4-way settlement conference, if it's just the 2 spouses together, you go through, look at property division, assignment of debts, spousal support determination, custody visitation, and child support. Now, one of the opening questions I asked is there anything of this that can be omitted? Yes, a couple things. First of all, if you have no minor children, then the last two matters go away. So without children, you don't need to worry about custody visitation, don't need to worry about child support. Also, if the two spouses have approximately equal incomes, then there may not be a reason to look at spousal support. And so now you're simply doing the property and the debt analysis in that. So that's kind of our 50,000 foot overview of the 5 things we have to do. And in the next coming presentations, we're going to break each one of them down and look at them in more detail.